Hello, everyone. Welcome to Court with Krissy. It's been a bit since I've had to make a phone call to someone behind bars. Do they say this call may be recorded for training purposes, or is it we're listening? Let me know in the comments. We've got Night Court with Judge Wiggins. I hope you like it. Court with Krissy is now in session.
Person at the jail, what is your name?
My name is Dustin Failer.
This is case number 2541198 FY, the people of the state of Michigan versus Dustin Lee Failer. Mr. Failer, what is a good mailing address for you? Did you have the opportunity to meet with somebody from the defender's office?
I did, sir.
I have a complaint that alleges that on or about September 25th, 2025 in Clam Lake Township of Wexford County, it is alleged in count number 1 that you committed the offense of domestic violence upon Chelsea Aaron Smith as a third offender. That is a felony punishable by up to 5 years in prison and or a fine of $5,000. Additionally, the prosecution has elected to charge you as a habitual fourth offender, meaning that you have at least 3 prior either completed or attempted felonies in your past. That makes that 5-year felony a life offense. Do you understand those charges and the potential penalties?
I do, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
As of right now, I'm going to request a appointed attorney.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter not guilty plea on your behalf and will set this matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
Yes, sir.
You also have the right to be considered for bond. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 07, I show operating while visibly impaired. 07, an attempted financial transaction device crime. 09, retail fraud third. 09, operating while visibly impaired and failed to stop at a personal injury accident. 09, possession of a narcotic less than 25 grams. 11, a driving while license suspended and a domestic violence. And 13, driving while license suspended. 16, allowing a suspended person to operate. 16, home invasion third. 17, a financial transaction device crime. In 22, a domestic violence second and a domestic violence. In 24, there's a possession of meth. And in 04, there's a case under 4A. Mr. Failer, are you on any type of supervision for that 24 possession of meth?
I am.
Is that probation or parole?
Probation.
All right. When are you done with probation?
I think I got 36 months, and I think I'm maybe a year into it, a little bit more, a little less than a year. I still got
you got some time to go yet?
Yes, sir.
Do you know, have they done any type of violation on you yet?
I have not heard anything yet. No, I have not heard that.
All right. Any comment regarding bond from the defender's office?
Yes, Your Honor. When I spoke with this defendant earlier, he advised that he didn't believe there was any probation holds on him presently. We realize that may be subject to change. But I would ask the court to consider a low monetary bond in this situation. I do realize that these are serious allegations, but I believe that any concerns the court has can be overcome with bond conditions. I don't doubt he would obey a no contact order with the alleged victim. I don't have a copy of the complaint, so I don't know if drugs or alcohol were alleged to be involved, but if they were, I trust the people to mention that, and I don't doubt he would obey any testing conditions, be drugs, alcohol, whatever the case may be. He's highly motivated to get to his employment, as he did note he has 2 different seasonal jobs. He does want to make sure to continue to work until the snow comes, because we never really know when that's going to be in Michigan, but he needs to get as many weeks in as he can so he can qualify for unemployment, survive the winter, things of that nature. I would ask the court not to set the bond too high for him to be able to realistically post it, being that type of a working man. Thank you.
Mr. Carnes?
Thank you, Your Honor. The allegations here is the defendant threw a lighter at the victim, hard enough to leave a welt, that state trooper noted. The defendant was cooperative with the police and did admit he was only acting this way because he had relapsed on meth and was high, which is consistent with the troopers. What the trooper noticed about is how he was acting. I would ask for random drug testing, a no contact order with the victim, and I do think a monetary bond is appropriate. I'll leave the amount at the court's discretion. Thank you.
All right, thank you. As a condition of bond, defendant is to appear as ordered, keep his contact information current, not leave the state of Michigan without permission, and to commit no new crimes. I'm going to order that there not be any alcohol consumption in random testings. I'm also going to order that there be no controlled substances, including recreational marijuana, and he'll be subject to random testing for those. I'm ordering those based on essentially defendant's admission that he had relapsed. While he may have relapsed on a controlled substance, I also don't want him turning to alcohol as a substitution for that. There will be a no contact with Chelsea Aaron Smith. Mr. Failer, you are not to purchase or possess any firearms or weapons. You are not to act in any threatening, intimidating, and harassing behavior. I will note that I am familiar with Mr. Dustin. I represented him in the past. I've prosecuted him in the past, and I've not known him not to appear, so I don't consider him a flight risk. But this is the defendant's alleged 5th domestic violence, so I do consider him a threat. And so therefore, I believe these conditions will help address that. I'm also going to set a monetary bond in the amount of $2,500 cash surety. That's it from the jail. Thank you, jail.
Thank you.
Thank you, Your Honor.
All right, Mr. Harrison, I've closed the breakout room, so he'll be with us in about a minute.
Just point of clarification, is this asserted as a bond violation from today's bond?
It is, yes.
Okay. All right. We will,
Yep.
He'll respond accordingly. He'll make an admission.
Okay.
Now, is he also on probation?
He is for a domestic violence.
Because he
No,
got
possession of
arrested
meth. I'm sorry. It's a possession of meth.
Yeah, but does he have new DV charges is based on today? Or
So
yesterday?
for us, I just arraigned him on a domestic violence
Okay. All right,
third
I got you.
as a HAB 4.
Got you.
At the time of the arraignment, he hadn't received a probation violation. I don't know if he has yet or not. All right.
Well, he soon will. Either way. Okay. We'll deal with that separately, though.
All right. We're on the record in the people of the state of Michigan versus Dustin Lee Failer, case number 25419-8FY. We're here after hours. It's about 10 after 5. The court wanted to deal with this issue because I'm at a conference tomorrow. I received a bond violation request that the defendant had contact with the victim from jail on today's date from 2:52 to 3:01 p.m. Defendant was arraigned this afternoon. I'm not exactly sure what time his arraignment was, but we started at 1:30. Mr. Failer, I know you had requested counsel this afternoon when I arraigned you. I'm not sure if Mr. Harrison is your appointed counsel yet, if that's even happened, but he is appearing at this point for the bond violation. So Mr. Failer, you also have the right to have a contested hearing in this case, or you have the ability to plead guilty for the violation. Have you had adequate opportunity to discuss the issue with Mr. Harrison?
I have, sir.
All right, Mr. Harrison, how does Mr. Failer wish to proceed?
Mr. Failer's prepared to make an admission, Your Honor.
Is that true, Mr. Failer?
Yes, sir.
All right, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Failer, then to the allegation that you violated your bond by calling the victim, who's Chelsea Aaron Smith, from the jail today between the times of 2:52 p.m. and 3:01 p.m. How do you plead?
I plead guilty.
Is it true that you contacted her by phone during those times?
Yes, sir.
And that was after you were arraigned on these charges today?
Yes, sir.
And you knew the court had placed a no contact order in place?
I did.
And you made that call knowing it was in violation of the no contact order?
Yes, sir.
All right. Mr. Harrison, do you believe the defendants provided a basis to accept the plea for the bond violation?
I do.
Mr. Failer, has anybody threatened you in order to get you to plea?
No, sir.
Has anybody promised you anything?
No, sir.
And is your own free choice to plea?
Yes, sir.
All right. Based on the defendant's admissions, I do find that he is in violation of his bond by violating the no contact order. Mr. Harrison, bond was set at $2,500 cash surety with the provisions of no alcohol, no drugs, no recreational marijuana, and random testings for both. That he not have contact with Ms. Erin Smith. That he not purchase or possess a firearm or weapon or have any threatening, intimidating, or harassing behavior. Any comment regarding bond?
Well, yes, Your Honor, Mr. Failer was in a position to post his bond. This was an act of desperation. He really didn't have anywhere, at least in his own mind, anywhere else to turn to try and rectify his current situation. There's a lot going on in their lives together. They're buying a house together. His father was recently diagnosed with a serious medical issue. There's a lot going on right now. He wasn't thinking clearly. One thing that he said to me that I was actually happy to hear him say was he was concerned that it not be looked at by the court as him flipping the bird to the court, being disrespectful to your bond requirements. And that was important for him to tell me, to tell you that this was just an act of desperation and not thinking. It wasn't purposeful and, hey, screw that judge, I'm going to do what I want anyway. If he had it to do over, of course, he wouldn't do it again. I don't think this changes materially any condition of his bond or his suitability for that bond. And I would encourage the court to accept this for what it is. Perhaps not just a simple lapse in judgment. Granted, I'll give you that, but a mistake, Your Honor. That's all this is. Thank you.
All right, thank you. Well, the court has no other way to take it other than Mr. Failer can't be trusted with his terms of bond. He's violating bond before he's even released from the jail. And that's while he's in jail, knowing that his phone calls are being recorded, knowing that things are being looked at. It gives the court great concern for what's going to happen if he is released. So the court is going to modify bond. I'm going to keep the conditions as they currently are set with a couple additional additions. I'm going to add a GPS tether for house arrest. Terms to be set by community corrections.
Okay.
Hey, sir, can I say something?
Mr. Harrison?
Sorry.
I don't think that's a good idea, Dustin.
Sorry.
Okay.
I'm also going to increase the bond amount to $25,000 cash surety. Mr. Harrison, you and your office know how to do a bond motion if you need to, but for the time being, that is the order of the court. So it's previously set with the added conditions of GPS house arrest and bond increase to $25,000 cash surety.
But that could be surety. Okay. All right, I understand.
All right. Thank you, Jail. Thank you, Mr. Harrison.
Thank you, Your Honor.
Your Honor.